Panelists. I'm Josh Schimmels, publisher and CEO of the Los Angeles Business Journal, and it's an honor to host today's discussion on picking up the pieces, business in the aftermath of COVID-19, presented by our great friends at Michaelman and Robinson. Statewide restrictions are easing up, weekly it seems, and will be lifted almost completely in the coming months. Business as usual is going to look very different, and it's going to continue to evolve. Today, we have an opportunity to hear and learn from an outstanding panel of subject matter professionals on many different post-pandemic related issues. We're going to cover topics such as OSHA mandates, safe workplaces, vaccine requirements. Can you require them with the employees? Should you? Ppp loan forgiveness, litigation, insurance claims, bankruptcy options, and we're going to give an overall economic outlook. We appreciate those of you who submitted questions during the registration process, and we were able to incorporate many of them into the conversation already. We will also be addressing a selected few of them at the end of the panel, so you won't want to miss that. Well, we have a ton of great information to share. We have a great panel, so we're going to hop right into things right now. It is my pleasure to introduce today's speakers from the firm of Michaelman and Robinson. First, Howard Kamai, partner. Mona Hanna, Office Managing Partner in Orange County. Brian Johnson, Partner. Dana Kravitz, Firm Managing Partner. And today's moderator, Sanford Michaelman. He's the Chairman of Michaelman and Robinson and member of the Federal Reserve Bank of San Francisco's Board of Directors. Sanford, welcome. Thank you so much for being here today. It's been a pleasure to work with you on this.
Thank you, Josh. And thank you to the Los Angeles Business Journal for arranging this. I think it's very timely. As you pointed out, we're sort of emerging from COVID, and there's a lot of different things that are changing from the regulatory landscape as well as just in general. How do we conduct business after what we all went through? And when the panelists and I were talking about what do we want today's presentation to be, we debated, do we want to go into a historical look or not? And we decided we don't want to do that. Rather, what we wanted to do was to provide takeaway value for everybody that has joined today, and thank you for joining. But that said, it's important to post how we view the pandemic and the stages that we all went through and are going through. And it really breaks down into three stages. The first one is confronting, way back when in March, was confronting the fact that we're in a pandemic, the virus. What does it mean? The shock to the system. The second one was once we came out of the first stage, how do we adjust? How do we live in this new normal, if you will? And then the third, of course, is emerging from the pandemic, the first two stages. We decided that we're going to focus on the third phase, the third stage, which is emerging from the pandemic, COVID, if you will. That said, at the very end, I will be addressing the first two stages, so I can lay a foundation, if you will, for how I'm viewing the next 12 to 24 months. With that, let me go into a little bit deeper introduction to the panelists so you get a sense of what they're going to be talking about. The first will be Dana Kravitz, who is in our employment group. His practice is advising employers in all kinds of different situations. And of course, lately it's COVID pretty much all the time. But what he's going to be talking about is that healthy tension between employers who are debating mandating their employees come back to the workforce, to their office, as well as employees' desire maybe not to come back. And how do you overlay vaccines and vaccination mandates? So Dana's going to be addressing that tension that exists as we're rolling out of COVID. Next, we have Brian Johnson in our Chicago office, who is the chair of our COVID practice. And I guess I would say, sadly, we actually have a COVID chair practice. Sorry, Brian, but we have one, and thank you for serving there. He was on the front lines of the entire shutdown. As the fiscal packages were coming out of DC, the CARES Act, Brian was already giving commentary in the draft phase of it. He's going to walk everybody through some of the issues that exist as a result of the different fiscal packages that have come about. Not only the audits from PPP, but some of the tax ramifications and things of that nature. Next, we have Howard Kamai in our Los Angeles office, who chairs our restructuring and bankruptcy group. I like to say that Howard's presentation is time to face the music. He's going to walk people through these deferred liabilities, these things that people we're using COVID as a great excuse, but rightfully so, on not paying rent, things of that nature. But as that's coming to an end, how do you address that? In court, out of court, court being bankruptcy, perhaps. And then next, we're going to have Mona Hanna, who's in our Orange County office and is the department chair of all litigation nationwide. Mona's on the front lines of that as well, having filed some litigation on behalf of clients against the SBA and Treasury for some of the things that she'll be talking about. But she's going to be talking about what I call deferred maintenance, if you will, the deferred compliance, the deferred updates, the pushing of contract obligations, and what the hotbed of litigation looks like as we emerge. And then finally, I'm going to be talking about, from my personal view, COVID's impact on the economy and how that overlays with the legal advice that we give to our clients to help give you some tangible takeaways as you look forward. So with that, Dana, I'm going to turn it over to you to talk about the employer-employee relationship.
Thanks, Sanford. I appreciate that. And thanks to the Los Angeles Business Journal. We're certainly happy to be here and hope throughout the time we have together that we share some pretty important information and there's some good takeaways. I can say this, as you can expect, employment lawyers have been extremely busy over the last year. Harkening back a year or so ago, a lot of time spent on decision-making relative to furloughs, unfortunately putting some people on a layoff mode and trying to grapple with the ever-changing law at the same time. And so now we're actually pretty pleased to be in a position that we're talking about reintegrating the workforce and getting people back to work. And in that, there's a lot of discussion that surrounds whether or not one should mandate as an employer vaccines in the workplace, or whether you should have some lesser standard than that. I can tell you, having kind of looked around the country at what major corporations and smaller companies are doing as well, it's about half of all companies that right now are undecided. They're not sure how they want to approach it. You have maybe 10% that want to implement a mandatory policy, and you got a bunch that are already coming to the place that they want a more relaxed standard, where they strongly suggest a vaccine be obtained, but they are not necessarily going to the place of mandate. But I do want to spend some time today and talk about a workplace where vaccine is mandated and how that plays out. But right now, you can look at our country and see probably a 50-50 split ultimately as to how companies are deciding to work through this. So, I'm largely just paying attention to Department of Fair Employment and Housing here in California, looking at what the EEOC guidelines are coming out, paying attention to Cal OSHA. It certainly had its challenges throughout the course of the year, trying to look at local, state, and federal and making it all work. And for those that are, in operations, running a business, or sitting in HR, I'm sure it was a challenging year, to say the least. If we go into the place, though, of a mandatory policy, what my recommendation is going to be is that any company that does that, you need to have that policy in writing, and it must be at all times looked at uniformly. You have to apply it in a uniform fashion. If you fail to have it in writing and you fail to implement it uniformly, you're headed to a disaster. And then the third prong on that is you have to be in a position where you've trained your managers and supervisors as to what your policy is, so there's even-handedness as to how it's applied. If you go to a mandatory policy, perfectly legal to do it, companies are going to do it. You need to be aware that there are really two exceptions to that to pay attention to. And that has to do with an employee that is refusing to vaccinate, even though it's mandatory, as a function of a medical condition or disability, or an employee who has a strong religious belief and therefore is opting not to be vaccinated. Those are really the only two circumstances that we pay attention to as employment lawyers in terms of why someone under a mandated environment would choose not to, at which the employer needs to pay attention to. You can't ignore it if it comes to you and an employee says they're not going to vaccinate as a function of that. You have to be in a position to talk to the employee. We're talking about an often used term, engaging in the interactive process, where you start to talk to your employees and get a clear understanding of what's motivating their decision, what the rationale is, and how you're going to approach it. Once you engage in that interactive process, it's a function of accommodation. We don't just tell an employee who otherwise isn't going to get vaccinated under a mandated environment that you no longer work here. They in fact can work there. And the question is, how can you accommodate that worker who falls under one of those two exceptions? It could be that they work on site, but they're in a conference room. It could be that they have been working remotely and can continue to do so. The point is, you can have that environment. It's perfectly legal to do it. where you can have an employee who can otherwise, under those two exceptions, decide not to get vaccinated, still under a mandated environment. Again, though, my takeaway on that is you've got to document that interactive process. Mona's going to go into a lot relative to the litigation. The last thing we want is an empty personnel file that has no documentation on the decision-making process. When you talk about whether an employee who doesn't want to get vaccinated can stay in the workplace, the issue becomes of whether they are a direct threat to the safety of others. And that direct threat is looked at the duration of the risk, the severity of the potential harm, the likelihood of the harm, and the imminence of the harm. And that's sort of a four-pronged test that you're going to look at to determine whether or not there's a direct threat, and then make a decision. One of the things that we're mindful of as defense lawyers representing employers is that retaliation is a very common cause of action brought by the plaintiff's bar. And if you're going to be doing an analysis of an employee who's otherwise chosen not to get vaccinated and giving one of the exceptions, you need to be careful how you approach that employee, because a retaliatory action being brought is not uncommon. So definitely look at ways to accommodate, and definitely document that accommodation. I've been asked the question whether or not, if you don't have a mandatory vaccination environment, would you have liability for otherwise choosing the strongly suggest or some lesser standard in terms of your environment? In other words, is there liability if you don't make everyone get the vaccine? I come down on that very clearly. Yes, there is liability. There is the potential that you've created an environment where it could be in unsafe work conditions as a function of not having people in that workforce that are vaccinated. So there is potential exposure. So you want to be mindful of that as you decide on your policy. Other employers, larger companies, are also taking the position that if we're going to have a mandated environment, or even if we're not, we want to encourage people to get vaccinated. And the discussion becomes of whether or not you can do vaccinations on site, whether the employer can bring in a third party and talk to these employees and say, look, we're either mandating an environment or we strongly suggest that you get vaccinated. Therefore, we've brought in a third party to help administer that. Perfectly legal to do that. But with that comes additional concerns. Those concerns involve the pre-screening process. When everyone gets a vaccination, they fill out some substantial forms, giving a lot of background as to their medical condition. And in that, because you've brought in that third party and effectively they're your agent, you as the employer are now in possession of private medical information. Privacy laws kick in, and you need to be mindful of that if you're going to take in that information. So you can do it, absolutely, but be mindful that if you're going to do on-site, there's a heightened awareness you should have with respect to potential liability. Now, a lot of the times I get asked the question, certainly as we all move to remote over the last year, an employee who says, hey, I don't want to get vaccinated, but I work remote and I'm super efficient, so why would I have to come back? Let me stay. In a mandated environment where you want vaccination, that's not an option. If you're going to tell someone that you have to get vaccinated to work here, someone who says, hey, I want to stay at home and I want to work at home and not get vaccinated because I'm so efficient remotely, that's not good enough. If a person says, hey, I'm scared to get the vaccine, that's not good enough. If someone says, my family members are susceptible to getting sick, therefore, I need to stay home, that's not good enough. If you're going to go to a mandated environment and require people to get vaccinated, someone can't choose outside of those two exceptions I talked about, medical condition / disability or religious, they're coming back to work and they're getting vaccinated. Let's be pretty practical about that though. If you have a situation where you've implemented a mandatory environment, imagine what happens if you come to learn that one of your key employees, someone in the C-suite, a top salesperson, take your pick, comes to you and says, you know what, I don't believe that the vaccine even works and I'm anti-vaccine and I'm not getting it. What do? You just put out an environment that says it's mandatory. There's no real option there. At that point, you're either going to have exceptions swallow up the rule, which is going to lead to liability. Again, the first thing I said is a written policy and implementing it in a uniform way. So if you're going to draw out exceptions that are not the legally recognized ones, you're going to have a problem. So really the advice that someone called me is you're going to have to let that person go. Now, unless you know everyone in your environment and what they're going to do relative to being faced with the mandatory vaccination request or demand, I tread lightly there. You may not want to put that in place because that could be a real situation where you're having to let go really good people who otherwise don't want to get vaccinated. So do think about that. The other thing I get asked a lot is, what do we do about the environment with respect to third parties? We're all going to get vaccinated, or we strongly suggest that we all get vaccinated. That's perfect, but we have clients, we have vendors, we have customers, all types of third parties, FedEx, UPS, take your pick, coming through our environment every day. what do we do with respect to creating a safe work environment when you have that many people coming through? I think of a law firm. We have depositions on site. We have, a videographer. We have a court reporter. We have opposing counsel and the opposing side. What do we do? If you're going to have a mandated environment where you need to be vaccinated, you certainly can say no one can come in here unless you've been vaccinated, which lends itself to kind of what we're going to ultimately see, which is this notion of vaccination passports and proof. You've already seen that with respect to sports coming back online with venues where they're deciding that to protect our employees, protect the players, we're going to ask spectators to either get a test and show a negative test within 72 hours of the event or show proof of vaccination in order to gain admittance. That's something that we see trending towards in the workplace as well, that there may be the need to have people show their vaccination card in some fashion or negative tests in order to come on site. And that's just about trying to create an environment that protects your workers. OSHA, while not putting out strict COVID guidelines, did come up with OSHA, I should say, emergency temporary standards that effectively said you have to have a prevention program in place. You're going to have a hazard assessment that you do on site. You're going to have proper hygiene, social distancing, masking, reporting, different ways that you need to take that information in and record it, have a process for determining if someone's sick, when they can come back, how you protect the employees, what notification to send out, all the things we've kind of been doing already as people are going back online. But OSHA has put up those regulations as well, which we're trying to get our arms around as well. I have been asked the question about on-site, whether or not you want to be in a position where you do on-site temperature check. I know a lot of businesses do it. I will say in isolation, a temperature check in and of itself is not really good enough. I would be implementing a policy that says you should self-administer at home, take your temperature. If you've got a fever, if you're finding yourself in a position where you are not feeling well, showing any symptoms or signs, you call in sick, and that's perfectly fine to do, and I would certainly encourage that. With that, there's other things I think I would like to get into a bit. I want to come back to this notion of the employee who's scared. We're going to hear a lot about that, of employees saying, I simply don't want to come back into the work environment. We need to be in a position where we are clear of how we want that environment to look. I think that you're going to find through talking to your employees and getting a feel for what remote looked like, that there's going to be a push to continue to allow some remote working, that people are going to want the luxury and the flexibility of working from home. And that's really up to the individual employer to make that assessment. So be mindful of that. The question is definitely coming down. Make a decision if you want to have an environment where you're going to mandatorily, or if you're going to mandate vaccination, be clear on the point. Key takeaways, coming out of this type of session. Again, make your decision. Make sure that you put that in writing. Make sure you communicate it to the employees. Make sure that you administer it in a uniform fashion to avoid the notion of retaliation, and you should be fine. Lots of questions are going to come out of this. Like I said, the trends are towards vaccination passports. I will say, in preparing for this, there was really no point in preparing in February or March. Things changed to the day. And you've got, again, as was stated at the beginning, loosening of restrictions. And when you have that, you have ever-changing laws. Being mindful of state, local, and federal is challenging, but keep your eyes open. Things are changing. The alerts will come out, and you'll be fine. With that, I'll turn it back to Sanford with any questions.
Thanks, Dana. Lots of great information. I do have a question for you, and it involves incentives. We've seen around the country businesses trying to incentivize their consumers, change their behavior, of course, into getting vaccines. Krispy Kreme was giving a free donut out if you can show proof of a vaccine. There's a cannabis dispensary in Michigan that's doing pot for a shot. All different sort of ways to get this behavior going. That's third party. My question to you is, what about dealing with your employees? What kind of incentives can businesses put out there if they want to incentivize their employees to get a vaccine?
Yeah, I mean, that question came up. We saw that come through. The notion of incentive is a dangerous territory to go into, because the issue becomes one of even-handedness and the notion of potential discrimination as to how you roll out an incentive. If you're going to put out an incentive to the employees to encourage them to get vaccinated, if someone doesn't want to get vaccinated, let's say in an environment which isn't going to be mandatory, then in and of itself, that person is going to feel that somehow they're potentially a target. They didn't get the incentive. They may be looked at skeptically because the company otherwise had an overarching policy to say, hey, let's incentivize with something. So that there's a risk there. The other risk is that incentives by nature have to be de minimis. They can't be all that much. If you're going to throw $500 at an employee to go get a vaccination, that's going to be viewed as potentially coercive to put that much money out there. You also run the risk that when you start paying extra money, that could lead to wage violations. You got to take that money if you're non-exempt and calculate it into the regular rate of pay, and that could lead to overtime. So there's a host of reasons why you would not want to be doing that. Incentives should be small if you're going to do it. I mean, we're talking like a small gift card at best, water bottles, little things, some swag, little ways to make a nod to your employees that we're encouraging it, and you can get this. But I'll tell you, you raise Krispy Kreme, and I'd heard that as much as they gave a donut away for everyone who was vaccinated, they equally gave those who either didn't qualify or didn't want to. So they still had even-handedness as to how they rolled that out, even with the incentive they put forth. And I would say the same holds true and should hold true the way we handle that within the employment sector.
Thanks, Dana. And at the end of this presentation, Josh is going to put up a slide with all of our contact information. So if anybody wants to follow up with Dana with any of the, any questions or content that he put out there, feel free to do it. That's exactly why we're here. We're big believers in putting out that information. We started doing it in March, so this is just a continuation. Now I'm going to turn it over to Brian in Chicago to walk us through all the fiscal packages and the CARE Act, et cetera.
Thank you very much, Sanford. And again, to the LA Business Journal, thank you so much for putting on this great event. As most of us know, the CARES Act was a massive $2 trillion stimulus package that was passed in March of 2020. Among the many components to that act were two noteworthy components that I want to really discuss and focus on today. The first being the Paycheck Protection Program, or PPP, and the Employee Retention Tax Credit. First, with respect to the PPP, start at the beginning. What was the goal of the PPP program? And that was ultimately to get money in the hands of the American people to offset the devastating economic impact of the COVID-19 pandemic. While technically a loan program, practically speaking, the PPP is a grant program if the loan is used for allowable purposes. It was meant for small businesses, and they could receive 2.5 times their average monthly payroll figures up to $10 million in that loan. The loan proceeds must be used for certain allowable purposes, such as payroll, rent, utilities, etc. And one of the big hangups with the program itself was that the rollout was so quick. It was hastily put together, and many questions were raised in the early days of the act. And as a result, the SBA and Treasury issued guidance and direction, but did so in a piecemeal fashion. We as a firm have monitored these programs and their changes since the beginning, and we've advised our clients in real time. In addition to the first draw loans that were, in 2020, the Appropriations Act allowed for a second draw loan to become available in early 2021. You must have, to qualify, previously received and fully utilized a first draw PPP loan. You have to have less than 300 employees, and you must have experienced a significant decrease in gross receipts during any quarter of 2020, as opposed to that same quarter in 2019. The Appropriations Act also added some entities as eligible borrowers, and in fact, expanded the list of covered expenses to include business software or cloud computing software expenses, costs related to property damage resulting from vandalism during some of the civil unrest that took place in the summer of 2020, certain supplier costs, and then capital expenditures incurred to facilitate compliance with COVID-related safety standards. The current deadline to submit your PPP loan application is May 31st of this year. Now, many clients have come to us very recently concerned with the tax implications of the PPP program. And I'll tell you, the implications are generally positive. There are two key takeaways with respect to the tax implications of the program. Number one, under normal ordinary circumstances, a forgiven loan is going to be considered income for federal tax purposes. The CARES Act expressly changes that, and they go in and they say that forgiven PPP loans do not count as income, at least from a federal tax perspective. The second issue that we've seen, kind of go through metamorphosis is really about tax deductibility. Under the Appropriations Act, PPP borrowers who receive loan forgiveness may claim deductions for covered expenses funded by PPP loan proceeds. And that is in contrast to the position that the IRS took during all of 2020. So really, we've seen really positive treatment from a tax perspective. Because our discussion today is focused on the aftermath of COVID, I think it makes sense now to look at loan forgiveness in the PPP context. What we're seeing is, first of all, a much higher level of scrutiny on the back end than we saw on the front end. So it's going to be more difficult to get forgiveness than it was to initially get the loan in the first place. There are multiple application forms to choose from. That is generally dictated by the circumstances of both the business and the loan that it received. And then the PPP funds must be used for allowable purposes. Two categories here. Number one, payroll, which includes your typical wages, salaries, tips, etc. But it also includes vacation, sick leave, holiday pay, bonuses, and even severance pay. So there's a chance for borrowers to really tick up the payroll costs that they incur and apply those for forgiveness purposes. The second category is your non-payroll costs, which are mortgage interest, rent, utilities, and some of those new non-payroll costs that I mentioned earlier. Finally, you've got borrowers who have to use at least 60% of the PPP proceeds for payroll costs and no more than 40% on non-payroll costs. And in order to comply with the intent of the legislation, borrowers must maintain employee headcount and they must maintain wage levels to their pre-pandemic levels in order to see full forgiveness. If they fail to do that, there's a potential for a reduction in the loan forgiveness. I really think that begs the question then, what are some specific actions that borrowers can take in order to maximize their loan forgiveness? I think first and foremost, you must look to ensure that your employee headcount numbers and your wage levels are up to those pre-pandemic levels by the end of the covered period. After that, my second line of counsel would be to utilize as long a covered period as you possibly can. So you should be able to take up to 24 weeks as your covered period, and through that process can maximize the amount of payroll costs you incur. Now, this is important because the employee reduction quotient, if you do lose employee headcount, is applied against your total payroll figure. So you can have payroll, if your payroll figures are significant enough, you could potentially still achieve full forgiveness, even if you had a minor reduction in your employee headcount or wage levels. So that's a key takeaway there. Beyond forgiveness, the other sort of issue that we're going to see rear its ugly head during the aftermath of COVID is this idea of loan audit, right? So the SBA and Treasury came out with guidance that said that all loans above $2 million will necessarily be audited, and some loans under $2 million will be audited. So everyone, it's fair game for all. As a result, we've seen counsel clients on this issue often, and we have provided them with 5 actionable steps that they can take to prepare for that audit. So this is a good takeaway here. Number 1, identify a point person internally through whom all of your information will flow. That way they know what's going in and out to an auditor. Number 2, coordinate with your professional service providers, your accountants and your lawyers early on in the process so that you can achieve full strategic alignment for that audit. Number 3, identify all evidence in your possession on eligibility, use of proceeds, and forgiveness. This is important because those are the 3 categories that the SBA has announced will be the focus of the audit. Number 4, identify documents and evidence which support your necessity certification, right? So as part of the application process, all businesses had to certify that the loan was necessary to support ongoing business obligations. make sure that you have that evidence ready, that documentation ready, whether that's contemporaneous financial analyses or whatever it is, make sure that that's ready for the audit. Finally, number 5, identify any potentially negative evidence for that audit and develop a strategy for responding to or explaining away that evidence. I think if you follow those 5 quick tips, you're putting yourself in a really good spot to respond well to an audit relative to your PPP loan. That is, in a nutshell, what, the key points that I wanted to touch on in terms of the PPP program. And quickly, let's turn our attention then to the Employee Retention Tax Credit. This is a really powerful tax credit that has gained steam in 2021. It's a refundable tax credit against certain employment taxes paid by the employer for qualified wages during Q1 and Q2 of 2021. It requires a fairly significant decline in gross receipts or a government required shutdown in order to qualify. But if you do qualify, you are eligible for a tax credit of up to $7,000 per employee per calendar quarter in 2021. So you can receive up to a $14,000 per employee tax credit. The process is actually quite simple. The employer simply withholds employment taxes that it would normally pay in advance and then submits a form to the IRS along with the backup necessary to support the tax credit. If the credit, and this is a really key point here, if that credit is greater than your tax liability, the IRS actually issues a check to the business for the remaining credit. So really powerful legislation to take advantage of. The question that we often get is, how do these work in concert together, the PPP program as well as the Employee Retention Tax Credit? And the good news is that the law now allows employers who receive the PPP loan to also claim the Employee Retention Tax Credit for qualified wages. Now, the only caveat to that situation is that you cannot get the tax credit for those wages that you paid for with PPP money. So, many businesses, in my estimation, can and should take advantage of both of these programs, but because of the restrictions on the payroll side of things, it does take some planning. So, I think if you're interested in learning more about the interplay between those two programs, definitely seek advice from your professional service providers and put together a plan so that you can maximize, what you're getting out of these programs. That's all I have at this point in time. Sanford, if you have any questions for me, I'd love to answer those.
Thanks, Brian. Lots of great information. I do have a question for you. And you touched on this idea of guidance being issued out by SBA and Treasury, and talking about how the CARES Act was stood up pretty quickly, which is understandable in light of what was going on at the time. My question to you is, that's come through, is there's a lot of confusion over the guidance, which are known as FAQs, is the way they're pushing them out, the FAQs. The SBA and Treasury has been using the FAQs as some new effect in law. What's your perspective in terms of whether or not the FAQs are merely good to know or something that must be filed or you'll be in violation of law?
Yeah, that's a great question, Sanford. The short answer is FAQs are not law. The statute and the statutory language is the law, and the FAQs are simply guidance provided by the SBA. Now, if you're asking me whether you should follow those FAQs and comply with them, the answer is absolutely yes, if you're able to and maximize loan forgiveness. On the other hand, if there is something holding you back from following that guidance, those FAQs, I think that's a point to reach out to your attorneys and discuss your options. I think my partner Mona is going to be addressing some of the issues related to that during her presentation later today. Thank you,
Brian. Thank you, Brian. Next, we're going to turn to Howard Kamai in Los Angeles to walk us through the different avenues we may or may not utilize with respect to some of our, liabilities that have ballooned on our balance sheet as a result of sort of kicking the can. So over to you, Howard.
Thanks, Sanford. And I too would join in thanking the LA Business Journal for giving us the platform to convey this information. I'm going to start by bringing everybody back about a year to the initial COVID-related lockdowns. If you remember, there was a lot of fear of the unknown. The more time the shutdown went on, the more uncertainty and more the kind of intensity of financial fear of unknown. Companies understandably at that point went into a financial survival mode, cutting back where possible. A lot of obligations were deferred and kicked down the road. Rent wasn't paid, compensation was reduced, layoffs may have been increased, debt payments deferred. And I think it's fair to say that most people at that time really expected a tidal wave of bankruptcies to be filed. But interestingly, in retrospect, that tidal wave never came. In fact, the LA Times recently reported that overall bankruptcy filings were down 30% from year 2019 to 2020. And LA was no different. LA was down 27% with about 15% less business-related filings. I think the answer for that is clear, that money was being poured into businesses and individuals, which gave them the ability to forestall the bankruptcy decision. The government was subsidizing entire industries. Individuals were receiving stimulus payments and higher unemployment amounts. There were eviction and foreclosure moratoria. And I just want to remind everybody that bankruptcy is really a symptom of economic distress. It's not the cause of the distress. So that's why there's a lag in filings. But importantly, at some point, those moratoria, the subsidies, the stimulus, they're going to stop. And frankly, that's when the rubber's going to hit the road. But what does that road ahead look like for companies that are facing the potential to operate in a crisis mode on a go-forward basis? So it may be counterintuitive, but as a bankruptcy attorney, I try to keep my clients away from the bankruptcy court. So what's a company to do when these subsidies stop, the moratoria are lifted, and now that Band-Aid is kind of ripped off? Let me tell you, I have been counseling our clients that informal negotiations with your creditors in today's day and age really is the best approach. And in that, I cannot emphasize enough that communication is key. A debtor needs to be open and honest, conciliatory with its creditors. Humility goes a long way. And really, it's a good place for a debtor to be in a position to demonstrate their financial hardship, but have a realistic plan on how you're going to address these issues. Some people tend to equate opening the kimono as being weak. It's really not. It's today's day and age. That's the approach that seems to get the best result. In the alternative, creditors need to understand that pushing too hard may ultimately force the issue and force a company into a bankruptcy. And that possibly removes the ability, as you'll see later, for the company to take advantage of available assets or available funds or available loans that could really help the company and the creditors. So overall, I think it's a safe assumption that the best approach that we have used post-COVID shutdown is, whereas you used to threaten a bankruptcy, walk creditors through the parade of horribles that would otherwise face them, that is now really transitioned to a collaborative, cooperative, and a communicative approach with one's creditors to try to see how to best navigate the immediate future coming out of the shutdowns and the removals of the moratoria. But let's face it, for many companies, revenues have likely dropped. There needs to be a very realistic assessment of whether or not the company is going to be able to sufficiently return to adequate liquidity to service its debt, to service its obligations once these moratoria have been lifted. Can you otherwise adapt? This is a time to be creative. I don't usually use specific examples, but look at Spago Restaurant in Beverly Hills. They, along with every other restaurant, were prevented from indoor dining, which cut down a substantial portion of their available space. What did? They set up shop on the sidewalk. They built a big bubble so that their ability to service customers of the restaurant really has returned almost to pre-COVID levels. To me, that's an outstanding example of adapt and be creative. Consider whether or not you're eligible for a second tranche PPP. Can you get interim financing? Can you hold out for a potential third fiscal package that may be coming down the pike to help you? These are the types of considerations that one really has to be introspective about when considering how best to operate in a crisis mode coming out of the pandemic. But let's say that the conclusion to those questions is that I am not going to be able to meet my obligations going forward, whether it's deferred rent, whether it's deferred debt, and my negotiations really fell upon deaf ears. And the barbarians are at the gate. What can I do? Well, at that point, it is certainly appropriate to consider a bankruptcy filing. And just very briefly, the two main types of bankruptcies that customarily we'll see is one is a Chapter 7 liquidation, where the operations of the business cease and a trustee will be appointed to liquidate the assets and to distribute those assets essentially on a pro rata basis to creditors. It's inexpensive, relatively speaking, but obviously that's not where a business owner would prefer to be. What about a Chapter 11 reorganization? Well, the debtor or the company continues to operate and be in control of its operations. The bankruptcy code gives some breathing room and the ability for the debtor to negotiate with its various creditor constituencies, landlords, trade vendors, secured creditors. And the bankruptcy does provide a number of useful tools for dealing with underperforming assets, overpriced or unnecessary leases and contracts. And ultimately, as I'm sure everyone knows, that the goal is to submit a plan of reorganization that cleans up your balance sheet and allows the company to operate on a go-forward basis. But to be fair, bankruptcies are expensive and time-consuming, and sometimes those additional costs may kill the patient. What to do? Well, Congress has tried to jump in that respect and provide an additional layer of assistance when they passed what they call the Small Business Reorganization Act, or you may have heard of it as a subchapter 5. There are certain debt limits, there are certain expedient processes that a company can take advantage of. The intent is to make that type of a proceeding much more cost effective, much more expeditious, and importantly, Congress allows the company to pay for the costs of the bankruptcy over the term of any plan that they are able to submit. They don't have to come up with all of those fees and costs up front. So Congress has joined in and tried to make bankruptcy, while admittedly never a desirable outcome, at least available to more and more businesses that would not have otherwise been able to afford going through a Chapter 11 process. A lot of times I get asked in connection with a bankruptcy, well, will I be eligible for a PPP loan? I mean, let's face it, as Brian adequately explained, sometimes it can be free money and turn into a grant as opposed to a loan. Well, early on, decisions were all over the board about whether or not a bankruptcy debtor was entitled to obtain a PPP loan. Different courts around the country came to different conclusions. Companies were jumping into bankruptcy, then jumping out of bankruptcy to get a loan, to jump back into bankruptcy. So there really was not a lot of clarity until Congress passed the CAA, or the Consolidated Appropriations Act, in late December last year. Essentially, it established that if you've received a first draw PPP loan and then you file a bankruptcy, the normal forgiveness rules, including audits, et cetera, would apply. If, however, you're looking for a second draw PPP loan, you must certify on the application that you are not presently involved in a bankruptcy proceeding. Well, what did that really mean? It meant different things to different people in different courts around the country, until just last week, the SBA issued a clarification on April 8th. And what it says is, For a bankruptcy debtor that's seeking a PPP, here are the following rules that would impact the potential timing of a bankruptcy, and they're as follows. If an individual files a Chapter 7 and the discharge has been entered, then that individual is not presently involved in a bankruptcy proceeding. For a Chapter 11, if a plan has been confirmed, then the entity is not at that point involved in a bankruptcy proceeding and is eligible to apply. Of course, if either of those cases get dismissed, then that entity is not in a bankruptcy proceeding and can apply. But the takeaway and the important nuance that I want to make sure is heard is those determinations are made upon the date of the application of the PPP. So it would not be wise to put in an application, to file a bankruptcy and then put in the application expecting your discharge to come in. So that is the nuance that I want to make sure that is on everybody's radar. What though, if we've gone through the negotiations, they're unsuccessful, we've evaluated whether or not the entity can survive based on a revenue stream that is going to increase, but bankruptcy is simply not affordable or simply not available. What can we do to otherwise try to capture some of the value in our businesses? Well, there are alternatives. There are state court alternatives, which are candidly outside a bit of the main focus of my presentation, but keep in mind, for example, California has procedures like an assignment for the benefit of creditors that could be useful, where all of the assets are assigned to a fiduciary who sells them and distributes those proceeds. So for example, if you're a business owner that has some assets but really doesn't see it working out on the long term, those assets can be sold, for example, to pay off any 941 payments that may not have been made that may flow through to individual liability. So, I would like to see people consider a lot more negotiations, hat in hand, consider whether or not you have a viable enterprise, consider what possible assistance bankruptcy can do, including PPP. If not, you're not completely at a loss. There are out of bankruptcy court alternatives that may be helpful to at least assist you in capturing some value from your business. And really with that, Sanford, I would turn it back to you unless you have any questions.
Thanks, Howard. A lot of information, tremendous information about, if the unfortunate impact of COVID leads to a bankruptcy. The question I got was that nobody obviously seeks or desires to go into bankruptcy. Given everything that you've spoken about, what's the one takeaway you would tell everybody that's listening to this to avoid going into bankruptcy? What's that key tactic or strategy with dealing with a creditor that might save you from falling into a bankruptcy situation?
Sanford, that's a great question, because the answer that I'm going to give you may not be as immediately apparent as people may think, which is, let's go get a PPP, let's go get some free money, and that will stem the tide. What I would really like people to consider is, if they're facing these issues, get out in front of the issue, be proactive, communicate and collaborate with your creditors. I think that people will be pleasantly surprised at the amount of buy-in that they can get from their creditors to work towards an out of bankruptcy solution than having to go through the process. So while PPP money that's forgivable is certainly nice and helpful, I would really advise people to think about it, get out in front of the issue, have a plan, and communicate and collaborate with their creditors to hopefully avoid a bankruptcy.
Thanks, Howard. And I would echo that, in that, before COVID, it was this idea of maybe going to bankruptcy isn't something that people wanted to talk about, or for financial distress. The difference, I think, with COVID is that it was put upon everybody at the same time. So even the creditors, your counterparty, they have the same financial constraints. They might not be talking about it, but the stigma relative to these issues is somewhat gone because of COVID. So Howard, excellent. I totally echo that. I would definitely be advising people to be more collaborative than adversarial. With that, Mona, I'm going to turn it over to you to talk about all the things that people should have been doing that aren't doing, that's leading to potential litigation. Over to you in Orange County.
Thank you so much, Sanford. Yes, I think that all of you have touched upon how it is that COVID has really impacted our environment, and it certainly has had a significant impact with respect to litigation. We know that based on the deferred liabilities resulting from COVID, that we are going to see litigation surrounding specific issues. I'm going to focus on 5. Now, there's a lot more than 5, but I'm going to focus on 5 areas where I think that COVID deferred liabilities is going to result in litigation, and suggest certain ways that you may be able to avoid that kind of exposure. And the first category is one that 2 of the panelists have already spoken about, and that is PPP loan forgiveness. I think Brian mentioned that it was fairly easy to get the PPP loan, and now the question becomes, can I have that loan forgiven? And here's where the issue arises. The CARES Act provided for the PPP loans with a fairly low threshold for eligibility. But implementation for the loans is through the SBA and the Treasury. And in responding to questions about the PPP eligibility, the SBA has issued guidance in their frequently asked questions, which basically, to our minds, has really revised the eligibility requirements. And so in response to certain questions, the SBA has made certain comments that would lead certain businesses that believed they had eligibility to now believe they're not eligible. But again, and I want to stress this, the SBA guidance, these frequently asked questions and the responses thereto are not law. They are not binding. They are merely guidance. And if this is something that you question whether or not you are eligible for loan forgiveness, it is very important that you coordinate with your legal advisor. I'm going to give you a quick anecdote. We had a client who believed he was an entity that believed it was eligible for PPP loans. The new guidance came out that made them appear to be not eligible. We filed a lawsuit against the SBA and the Treasury. And it may be coincidentally, but within 2 weeks after filing that complaint, new guidance came out that clarified that our client, not by name, but by category, was eligible. That's the other thing that you have to be careful about. SBA guidance can change from day to day. It can be very arbitrary. So it's extremely important to stay on top of the guidance, to coordinate with your legal advisor and accountant to make sure that you are staying on top of and current with eligibility requirements. And if there's a question, you should definitely proceed with your rights to pursue an answer to that. Second category of litigation that we think is going to be related to this deferred maintenance, deferred liabilities of COVID is the one that Dana's spoken about, the return to work, the employer-employee relationship. Now, Dana spent a significant amount of time basically outlining that every decision that an employer makes, whether it's mandatory vaccinations, whether it's remote working or in-office working, all of those can lead to liability. One other area of questions that we often get is, can I use this return to work order to basically clean house, get rid of those employees that I really didn't want to keep in the first place? The answer to that is that kind of selective determination of who returns to work and who doesn't may lead to litigation. And so it's very important to avoid that kind of litigation, to have a policy that is well-defined and documented, to apply that policy uniformly. And of course, do not base those determinations on any protected basis, such as age or gender, et cetera. The other thing that I would counsel employers to consider is to include in their arbitration agreements and policy manuals arbitration agreements and class action waivers. Those are especially effective to protect employers from those kinds of mass litigations that can be avoided by inserting that kind of language. However, that kind of clause has to be significantly compliant with the law to be enforceable. And so I would encourage you to make sure that you're coordinating that with your advisors. Third category of litigation that we expect to see is for service contracts. We know that there is a host of contracts out there that have been prepaid and could not be fulfilled. It could be events, it could be season ticket holders, it could be service contracts, etc. Whether you are the consumer who has paid for a service that you did not receive, or the service provider that received payment but could not fulfill the contract, there are a few steps that you can take to avoid the necessary consequence of litigation for those instances. One is try to renegotiate that contract. That may be something that is available and both sides may be willing to do it. A second alternative is look at business interruption insurance. That may be an area that you can go to, whether you are the consumer that paid for the service or the service provider that was unable to perform the service. That may be a source of funding. So I would encourage you to look for that opportunity. The fourth category of litigation that we anticipate is for the landlord-tenant arena. We know that right now there's a prohibition in California for evicting tenants for failure to pay rent, but that's going to be in place until June 30th. And then at that point, tenants will be asked to pay 25% of the total amount of rent due between September 1st, 2020 to June 30th, 2021. What happens at that point? If you are the tenant, I would encourage you to take advantage of the tenant assistance programs. If the tenant is a business rather than an individual, I would encourage the business to look at PPP loans as a source of funding for rent. If you are the landlord, I would remind you that you are required to, and I encourage you to continue to make timely notice to quit and wait to see if you receive the necessary declaration from the tenant of financial distress. If you do not, you may then evict. And also you may evict for non-monetary reasons. So if you have a nuisance tenant or a tenant that is breaching their lease for a reason other than monetary, you may evict in due course. The final category of litigation that we anticipate is from the reality that we've all been forced to interact with the world through our computer, whether it's working remotely or whether it's video conferencing or webinars such as what we're doing today. And as a result of that, we have heightened cybersecurity concerns. So we now are going to be seeing litigation resulting from data breach because of the reduced security and operations for remote workers, privacy litigation based on the mishandling or improper processing of employee and or customer data without adequate controls, and claims of misappropriation of trade secrets, soliciting customers, and data spoliations. Things that companies can do to kind of head that off is to make sure that they're enacting policies and practices and enforcing secure handling, processing of organizational data. You want to require remote workers to use organization assets to conduct work rather than home computers, devices, and cloud storage. And you may want to consider digital fingerprinting technology to track trade secrets. Those are the 5 areas that I anticipate will be the forerunners in terms of litigation resulting from the deferred management, the deferred liabilities that we expect to see coming in the future. And again, to echo some of my co-panelists' final remarks, being proactive is really the best way to avoid liability on those fronts. And with that, Sanford, I'll turn it back to you.
Thank you, Mona. Lots of information. Before I ask the question that was posed to me, I am going to correct something that you said, which was the SBA's clarification of its FAQ after our lawsuit wasn't a coincidence. It was your stellar legal representation. I just got to throw that out there. The question I got posed was, when we went to COVID, all the courts around the country, federal and state, shut down and things completely backlogged. Now, as we're coming out of that, it hasn't stopped new filings. What does the landscape look like in terms of timing for people to get their cases back up and active again?
Yeah, that is definitely a question that the legal community and parties are asking. I think the short answer is be patient. We've literally had 12 months where courts have shut down, except for very few exceptions for emergency hearings. We have recently, I mean within the last 2 weeks, been receiving bulletins from various courthouses indicating that their jury trials are going to be back up and running in a very restricted capacity. So we anticipate major backlogs. We are seeing cases being set for trial years out, whereas prior to COVID, generally a case would be from filing to trial about 12 months, if not less. So there are ways to try to circumvent that. If you are the plaintiff and you want to get your case to trial, you can consider private trials. It's not a jury, it's a private judge, but you can maintain your right to appeal, etc. And if you're the defendant, you may consider taking advantage of the delay to find a business solution to resolving the litigation. But absolutely, we do intend to see a backlog and a delay with respect to trials moving forward in all jurisdictions.
Thank you, Mona. Now for the final presentation, I'm going to be talking about COVID's impact on the economy and how it intersects with legal advice in managing through the recovery, the way I personally view it. This is my personal opinion, looking out 12 to 24 months. When we first started, I was talking about the 3 stages of the pandemic, COVID, which is the confronting of it, adjusting and figuring out how to deal with it, and then emerging from it. I do think it's important to briefly touch on the first 2 stages, which lays the foundation for what it looks like going forward once we roll into stage 3. So I want to take everybody back to March of 2020, when in the first part of the month, we were hearing about lockdowns in northern Italy and other places. It was really when it hit right around March 13th, to 16th, that range, when we started seeing the shutdown orders, the shelter in place, whatever you want to call them. And the way we viewed it was basically like a light switch. You had this robust global economy and suddenly, boom, things get shut down. That was the time, that was the date that we entered into stage 1. We had to confront, what does this all mean? What does this enormous shock to a system turn into? So back then, what we did is we actually sat down and we started to analyze, what does this mean for not only us as a business, but for our clients as well. And one of the big things to always keep in mind is this wasn't a structural issue like we had in the Great Recession. Rather, you have to conceptualize or think about this as a natural disaster, an earthquake, a hurricane, things of that nature. And the reason being is the remedies, if you will, to dealing with this are entirely different than that of a structural problem that we experienced back in 7, 8, and 9. So once you have that, you can sort of put in the back of your mind, all right, this might be transactional. This might be temporary in nature, not like in a structural issue that you got to fix something that's embedded into a system. Then what we started looking at was the reaction of people in our environment, in our communities. And I looked at that from a behavioral point of view, which is in addition to law as part of my background. And what we saw was the typical reaction when something like this happens, which is 2 emotional reactions. Now, typically these don't converge at the same time. If they do, you get a unique outcome, which is what we all experienced. The first one is fear, and fear is defined as a perceived immediate threat. The next one is anxiety, and anxiety is defined as a perceived future threat. When those 2 emotional states combine, it gives you a different behavior, which is survival mode, which everybody experienced. When the shutdowns came in, everybody jumped into survival mode, which equated to a reaction of shifting or inverting ordinary and deviant behavior. Let me give you an example. When thinking about sheltering in place for a year, we all know people who have sheltered in place and until they got their first vaccine wouldn't leave. In pre-COVID times, that would, you call them a hermit, whatever you want, that would not be deemed normal. So when we knew that the outcome would be the inversion of these two behaviors, we had to then think about how do we actually define the threat? Is it the virus itself? And we concluded actually that it was not. What we concluded was the consequence of the virus, meaning from a health perspective, what is the morbidity rates? What does it look like if I get it? What is my survival rate? Back then, if you recall, it was unknown. You heard numbers as high as 10%, 5%. Ultimately, we know it's much lower than that. And of course, any loss of life is horrible, but you had to define what that threat was so you can manage through it. The other one was a financial or economic threat, right? When there was a shutdown, immediately, like the spout was turned off. Did this mean financial ruin? So once you knew that these behaviors were going to come into play, what we had to think about is what are the behaviors that are going to result? Now I'm going to talk about the financial side. Everybody can figure out the healthcare side, which was the isolation side of it. What it did is it allowed people to change normal behaviors. People were hoarding cash, if you remember, running to ATMs, pulling money out of banks. They were pulling down credit facilities if they needed them or not. They weren't paying their rents. They were letting covenant slips. They were knowingly breaching contracts because they were in survival mode. That's stage one. What does that translate into? Well, that translated into the population essentially being broken into three buckets. One is extreme concern. That's the fear and anxiety side. The second is moderate concern. I'm concerned, but I don't know exactly what to make of it. And then the third is mild concern. There might be some outliers who didn't really care. I don't buy it, but there might be that. So now we roll into stage two, that we've confronted this enormous shock to the system. Stage two is adjusting to this new normal. How do I deal with this, complete shutdown? Now, I have this behavioral state of fear and anxiety. How do you remove it? Now, let me just say that the behavioral part that I'm talking about, I wish were my theories. They're not. They go back many, many decades. These are things that have been taught for years. So how to get out of a fear or a situation of fear and anxiety? It's repeated exposure to information, so people have the ability to reevaluate what their fear is based on, what the risks are. Now, back in March, if you remember, there was mixed messaging going on. This is not a political commentary at all, but if you remember, there was all different camps. You don't need to wear a mask. It's going to be over before it starts. You need 2 masks. It's going to be horrible. Doesn't really matter where you landed on that. When we looked at it in March, we figured, okay, it's going to take us to June until we get some experience behind us and a little bit more clarity on the messaging in terms of how to deal with this complete shutdown. And what we were able to say is, once we get to that point, we believe that to be what we consider to be the asset value lows in the pandemic, which pretty much turned out to be the case from our vantage point. Then what we predicted was there'll be a gravel road, if you will, from June to September. Why a gravel road? Because the information coming out wasn't consistent, so it would be bumpy. Good news, bad news, good news, bad news. But the one thing that we really paid attention to was how do you get to the out of this gravel road environment, which was September, and it really came down to getting 2 data sets. One was good news on a therapeutic or a vaccine, just the advancements alone. That news would calm people and get them out of the extreme and maybe into the moderate, if not moderate, into the mild concern. The second one was the fiscal packages coming out of DC, the CARES Act. Now, the CARES Act, as Brian talked about, was really an incentive to keep employees paid. It was a way to use banks and businesses as intermediaries to get money flowing through the system. Now, I personally believe the CARES Act doesn't get enough credit, and here's why. When you're thinking about a disaster situation in any type of environment like this, if employees are laid off, what do they tend to do? They tend to move back with family, friends, and they get completely dispersed. As a result, when the light switch comes on, if you will, businesses then have to recruit, and train. That takes resources and time, which means it extends the recovery. The CARES Act, and as we thought about it, is if it came out the way we were hoping it would come out, everybody knew back early on there was going to be some fiscal package that would evolve into what I consider a V recovery, which is a 12 to 18 month recovery. I could tell you we certainly were in a boat by ourselves back then when we thought this, but I still think it holds true today in terms of the way we conceptualize it. What happened in September? Well, I believe we had some good news on the health front, which were some advancements, perceived advancements, at least on the therapeutic side, as well as some of the reports coming out about Moderna and some of the other vaccines that people know. The other good news we had was on the economy, the unemployment rates, which I'll get to a little bit later, were starting to slide. So people were starting to come back into the workforce, and we were able to start seeing this activity again. If you remember, people were starting to take walks, socially distanced, having conference calls on walks, going to restaurants to the extent they could, or ordering in. So you started to see this mobility again. What was great about that? You started to see a reweighting from the extreme concern and the moderate concern. So you started seeing people move over, which is a mitigation of fear and anxiety, which is great because you want people to consume again. You want the economy going. What was our big break? Our big break was the FDA approving the vaccines, of course, right? The recovery follows the virus, as they say, and I think that's true. So what we ended up having was when the FDA suddenly approved these vaccines, you have this aspirational shift of people in the extreme bucket going into moderate, and those in moderate going into mild, and some just leapfrogging moderate. But I'll tell you, we're not in stage 3 yet. I know the title is the aftermath of COVID, picking up the pieces. We're on the edge of it. And why do I believe that? I think there's 3 things that need to happen until we get into what I'd like to think would be the uptick on the V of the recovery. Again, these are my personal views. One is vaccines domestically appear to be going out at a rapid pace, but globally, we need to see vaccines coming out in a much faster pace. And if not a vaccine, some therapeutic that gives some calm to the environment. Why? For all the reasons people know from a global perspective. It allows mobility again, tourism, but most importantly, it opens up supply chains that are otherwise clogged in different parts of the world. So that obviously impacts, different things, commodity pricing, et cetera. So I think that needs to happen. I also think what needs to happen, and I think is a watershed moment, are school reopenings. Now, I'm not saying do it frivolously. It's got to be safe first and foremost. But the reason I think schools reopening are important is for pretty much the obvious reasons, which is it gets kids back into an environment, not only as feeding centers, but learning, stress levels drop down, but also because you'll have people that are juggling home life, their household obligations to their work life, that should be mitigated. We have approximately 8 million people still on the sidelines from the pre-COVID time period. And we also know that women are disproportionately hit in this environment because of childcare issues. If they go back to school, that population gets to come back into the workforce. The third one is some of the negative and positive press still has to work its way through. Or I should say news information. By way of example, everybody knows about J&J in the last couple of days with the 6 blood clots, roughly 1 in a million. But still, I take that as a good sign that the FDA is jumping on that and taking advantage of that. The obvious outcome of that is it's going to slow down some people's belief in the vaccine as well as getting a single shot on J&J. The positive news, though, are things that happen like today. The 7-day average on morbidity is at its low compared to October of last year. That's fantastic news. So we're starting to see some things develop, which is really great. So I pick September as sort of that velocity going up. Now, what do I think that looks like? I think there's going to be a dramatic increase to productivity. Now, I always hear people saying how productive they are at home and because of COVID. I frankly reframe that to say they're just not as unproductive as they thought they were going to be. And a lot of this is you're looking at the data and trying to analyze it. Well, I'll tell you, there's been some great studies that came out recently from Harvard Business School and NYU and a couple of other researchers When looking at productivity, they define it as time, talent, and energy, and they further define that. And when they break that down, they have some great data. They pulled data from 3.1 million people, 16 global cities, and they found things like the number of meetings went up 12.9%, the number of attendees increased 13.5%, the time per meeting decreased. And when you sort of shake that up, put it in the blender and what comes out, what they found was actually there's inefficient collaboration, wasteful ways of working because people are trying to figure out new ways of working, and a decline in employee engagement. And overall, what they found is there's a 6 to 10% loss of productivity on a macro level. I personally think the numbers are going to be higher when we look back on this in about a year. That doesn't mean it applies across every industry. Some industries that are very big on employment engagement, especially the tech space, have actually seen an uptick in productivity, but that's more of the outliers. So now let's talk about the numbers to just give you some kind of context as to where this all shakes out. Pre-pandemic, we were at record lows on unemployment, as people know. It was roughly 3.5%. In April of 20, when I would say we were at the height of the shutdown, the unemployment numbers were coming out at 14.8%. But now if you take the misclassified, and that is defined as employed but unpaid leave, it got as high as 16 to 17% by some people's calculation. So just think about that. In 30 days, we had over a 4 times increase to unemployment. That's dramatic. But the good news is, and this is where I think you see it going from extreme concern to moderate to mild, as of today, it's roughly 6%. So the drop on the unemployment rate is fantastic. Now, of course, we have a long way to go. There's still 8 million people that are unemployed as compared to beforehand. But what I believe, I think with September, with pegging that as the uptick on the V recovery, you're going to see some of those people coming back into the workforce. The other thing to keep in mind, it's a debate on what is considered full employment. I would generally say it's anything at 6% or less, and we're starting to see that. And I start to, see more of that uptick, and people are seeing it in the jobs reports, et cetera. So what am I looking at? When I look forward 12 to 24 months, I see a dramatic uptick in economic activity personally. I think there's going to be a lot of pent-up demand for consumption. One of the things that I just want to close on, as we talked about fear and anxiety, that gets mitigated through the exposure to information. The one thing that happens once you go from the extreme concern to the moderate/mild, people get a sense of relief and they get elation. This is the whole concept of adrenaline junkies. Once they realize or feel that it's safe to go out because of the vaccine or therapeutic, that pent-up demand tends to be overcompensated. People are going to travel more. People are going to spend more. They're going to try to make up for that lost time. So I think that's going to be something that's going to be a driver to the economy in a very big way. So why am I raising that now? I think that when you put into context some of the suggestions and things you're hearing from the other panelists, to put in perspective or put that lens over it, what that means. I'll just give one quick example. Howard Kamai was talking about negotiating with potential creditors. Well, if you're a creditor and you're dealing with a debtor and you buy off on this concept of what I'm saying in terms of economic outlook, well, maybe you want to go a little bit slower and not throw them into a BK or push them too much because their businesses might rebound as we start to come out of this. Of course, hope isn't a strategy, but that's the collaboration piece. So I hope that the information we provided today was helpful. I hope it gave you something to think about and some takeaways. Before I turn it over to put up a slide on our contact information, I did get some more questions that I briefly want to throw out in the last few minutes. The first question is for you, Dana, which is, can you speak to California supplemental sick pay related to COVID-19?
Thanks, Sanford. I've been getting a number of questions rolling in and on my email as well. So let me just say that to the extent we don't get to them today, I will personally respond to everybody who's reached out to me. So we'll get your questions answered. With regard to supplemental sick pay, this is one of those situations where I said keep your eye on the law and how things are evolving and changing rapidly. This is a March 29th law that goes into effect in California, retroactive to January 1st, that gives 80 hours of sick pay to employees who need to take time off work, either to get a vaccine or to care for someone who has COVID, or because someone, the employee, him or herself, has COVID or is showing symptoms. So it's just another form of relief for employees in terms of, giving them compensation if they have to take time off if they're sick. I will tell you, I got a collective groan from employers, like, another sick pay, another 80 hours. Where are we coming up with the money? I understand that this applies to employers that are 26 or more employees. The question, we talked about some of the incentives earlier, whether or not, if you're fewer employees than 26, whether you want to be offering something like this up to your employees. So those issues come into play. I can envision scenarios where people hear that someone needs to take the time off because they're sick or caring for another or getting the vaccine or for whatever their reason is, and employers being prone to want to find out more, asking questions. Well, didn't you get a vaccine? How come you're sick? Shouldn't you have had the vaccine? And that's the danger where, we get into those issues of retaliation. We get into those issues of delving too far into medical, too far into someone's personal business, medical business, disability. I'm going to ask those employers to pull back. Don't put yourself in the position of going so far. You can ask a question, did you get a vaccine? You can ask the question if you intend to get the vaccine. It's the why portion that you want to stay away from. So this is another law that's coming into effect. You'll see a lot more over time, and just be careful as you navigate through. Back to you, Sanford.
Thank you, Dana. And I'm going to respect everybody's time and end on time. But with that, there's time, I think, for two more questions. Mona, this is to you. How can I obtain financial documentation from a residential tenant that is claiming financial hardship?
Sanford, I think
you're on mute.
Frozen.
All right, well, so Mona's frozen, so I'm going to go to the next question, which is actually a question for me, which is, what do I see as the long-term impact relative to COVID and the economy? This is just my belief. I think there's two things that people have to sort of get their head around. The amount of money that's been deployed in these fiscal packages has to come back some way, which necessarily goes to increases in taxes. Now, is that something that people love doing? I don't know anybody that loves writing a check to the IRS. If you do, you're crazy, but be that as it may. I actually embrace it. And the reason I say that is we've got to pay it back. We've got to reduce the deficit issues, but also people have to remember that our largest employers are our states, our cities, and our municipalities. Without that tax revenue, if they've got to be laid off, you're talking about a spike to unemployment again, and then you have some bad outcomes. So I think how we're going to deal with that tax in the least intrusive way is a big issue. Everybody knows the debate there. It's a real issue. The other one is the healthcare concern. This is actually my biggest thing that I think about when I look forward 3 to 4 years from now. The data is pretty clear that in a situation like we just experienced, people tend to ignore preventative healthcare. You've seen the data. There's some even data coming out recently about people who brush their teeth more often than those that don't, 3 times or higher, have less dementia, Alzheimer's, inflammation, things of that nature. Those things tend to not be addressed in a situation that we just experienced. So what does that mean? If you roll forward about 2 to 3 years from now, those things will manifest themselves and the outcomes will be bad health outcomes. My concern is, what does that mean for our healthcare system, and what does it do in terms of putting pressure on that healthcare system, and how do we capture that environment as a result of what we just went through? I don't know the answers, but that's what I think the 2 biggest impacts are going to be. So with that, again, I want to thank you, Josh, for having us here and present. And I hope, again, everybody got some useful information, and I'm going to turn it back to you.
Thank you so much. How about a virtual round of applause for today's speakers? I want to thank all of you so much. Sanford, Howard, Mona, Brian, and Dana. I mean, just what great information that you gave us, and something for us to think about as we move forward in business. This is a constantly evolving subject. I think it was something that Dana mentioned early on. you can't even prepare. When we first started talking about doing this just 8 weeks ago, you couldn't even really prepare for what it was going to be because so much has changed in that 8-week time period. And it will continue to change and evolve. So I think it's important that we all have constant updated information. Thank you for being such a great resource to us. I encourage all of our viewers and those of you who watch this on recorded version later, take a screenshot now so that you can see the contact information from each of our panelists and our moderator today. I want to thank our friends at Michaelman and Robinson really for creating this conversation and bringing us all together for such an important panel. I want to remind all of you watching and still with us that Monday's print and digital versions of the LA Business Journal will be highlighting this event. And there will also be a recorded version of the entire program available on labusinessjournal.com, probably by Friday, if not sooner. So thank you all for tuning in. Until we have a chance to see you again soon, please stay safe and stay healthy, everyone. We look forward to hosting you again soon. Have a good day.